You have to interpret the Constitution in a way that makes pragmatic sense. The Constitution is not a suicide pact. Even Justice Scalia, in his ostensibly textualist and originalist opinion in Heller, the DC guns case, said, well, of course you can't take a gun into a courtroom or into a courthouse. Why not? You can speak in a courtroom or a courthouse. There's a famous Supreme Court case, Cohen against California, that says you can wear a jacket that says the draft into a courthouse. So why not let people take guns into courthouses? Because it's a really bad idea, and even people who claim to be textualists and originalists don't interpret the Second Amendment in a way that creates those kinds of dangers. So all of those are ways of thinking about the Constitution. And the other thing that's important to remember is who interprets the Constitution. It's not just the Supreme Court. It's not just judges. Every public official in the United States takes an oath to support and defend the Constitution. And when they do their jobs, they need to think about what the Constitution forbids, even if no court is ever going to tell them it forbids that. And all of us as citizens, we interpret the Constitution as well. If you want to know who's had the biggest effect on what the 14th Amendment and its enforcement clause reads, don't just look to judges on the Supreme Court. Look to students like John Lewis as a 23-year-old who put their lives and their bodies on the line to change how Americans think the 14th Amendment applies or the like.